Hello, and welcome to another episode of Virtual Legality. I'm your host, Richard Hoeg, managing member of the Hoeg Law business law firm of Northville, Michigan. And today we're going to talk about an interesting story at the intersection of international politics, technology, and video games. Namely, as The Verge puts it here, that the U.S. has designated Tencent, as well as CATL, as Chinese military companies. The designation could make it harder for the owner of Riot Games, Tencent, and the world's largest EV battery maker, CATL, to do business in the U.S. So one of the leading questions that I had reading these articles, and I saw them in IGN, I saw them in CNN, I saw them in other places across the internet, is what does this mean for these companies? How did it happen? What does it not mean? And how might they fight it if they feel like it's an unfair characterization of what, at least in Tencent's respect, is ostensibly an entertainment company more than anything else? And so let's go on a journey through the U.S. Federal Register and a complex web of interlocking laws and designations. So as The Verge puts it, the U.S. Department of Defense has added tech giant Tencent and lithium-ion battery maker CATL to its list of Chinese military companies as reported earlier by Bloomberg, and we'll check out that article in just a second. The designation doesn't impose sanctions or a ban, but it could make it more difficult for the companies to do business in the U.S. So importantly, from a legal perspective, there are laws and lists and designations with respect to imports and exports and investment that the United States has passed that says, thou shall not engage in these activities if you appear on this list. We know these in terrorist lists. We know this in export controls and other areas of the law. This is not one of those things. You are named a Chinese military company, but as The Verge says here, the designation doesn't have a separate sanction or ban attached to it, but it could make it more difficult because, honestly, it's harder to attract investors. It's harder to enter into business deals if the U.S. government has labeled you as effectively a part of the Chinese military infrastructure. So it is important, and we'll see as part of this story, that the companies are going to object to the deleterious effects on their business propositions, on their investments, and everything else that happens when they're included on this list, and whether or not the U.S. government is doing it appropriately. The designations, as stated here by The Verge, originate from President-elect Donald Trump's executive order in 2020, but I've highlighted this in red particularly because this appears to be in error. Now, I don't blame the author here in The Verge. I don't blame the author in Bloomberg that says the same thing, because this is a series of interlocking laws. It's very confusingly written by the U.S. government, and I don't pretend here to be an expert on these international designations at the Department of Defense, but I was able to do research on this, and I do think, looking at the links that are provided here and the references made in Bloomberg, that this particular reference is in error. We'll talk about why in just a minute. But this goes on to talk about lawsuits and things that other companies have entered into with respect to this issue, and we'll get to those at the end of this video. Now, for the primary source material, the Bloomberg article here says, CATL, a major supplier to Tesla, joined Tencent on a federal register of entities deemed to have ties with the People's Liberation Army, the military arm of the Chinese government. Now, this in and of itself is a little bit reductive. It's a little bit ambiguous to what's actually happening in the law. We'll see that when we look at the legal language itself. But again, I really am sympathetic to journalists who aren't looking at these things every day, trying to articulate in clear, certain terms for their audience what's happening here, when, as we will see in just a minute, the law is really unclear itself. They do note that Tencent stock slid more than 7% in Hong Kong, notching its biggest drop since October. So even though there are no sanctions or no direct legal ramifications to this designation, it does matter to these companies. CATL's shares fell about 3%. While the Pentagon's blacklist carries no specific sanctions, it discourages U.S. firms from dealing with its members. While we understand the market's panic reaction, said one Citigroup analyst, we also believe its inclusion in the list does not necessarily suggest that there is sufficient evidence to confirm the decision was the correct one. So the U.S. government, the Department of Defense, goes out there and says, these entities are all part of the Chinese military infrastructure. This analyst, I think rightly, says, well, we don't have to assume that's the end of the story, that just because the deputy director of defense says this in a document, that they're ultimately going to be ruled as having some kind of problematic relationship to China. But reasonable minds can differ even on that score. And we see that this Bloomberg article discusses the ramifications a little bit further. They say China's foreign ministry condemned the U.S. sanctions and vowed to defend its company's rights. These are just designations, not sanctions, but okay, Bloomberg. And they also say, as part of this article, that the Chinese military company list stems from an order signed by Trump in late 2020 that barred American investment in Chinese firms owned or controlled by the military. Now, interestingly, This article in and of itself, as well as the Verge article, seems to identify its own error in writing this up, insofar as it says there are no sanctions, there are no prohibitions, there are no things that are barred from being designated on this list, and then later says that it goes back to a Trump executive order that barred American investment in Chinese firms controlled by the military. Those seem to be against each other. It's one of the reasons that it was flagged for me to research as part of this video. And if we actually look at the primary source material, we'll understand a little bit better what happened in this reporting. So in the Federal Register, this is where we see Tencent, this is where we see CATL. It says that Section 1260H, remember that section number, of the William M. Thornberry National Defense Authorization Act for fiscal year 2021, never accused the U.S. government of writing too short of a title for their appropriation acts, requires the Secretary of Defense to identify and publish a list of Chinese military companies annually until December 31st, 2030. The Deputy Secretary of Defense has determined that the following entities qualify as Chinese military companies in accordance with Section 1260H. And if we look at this list, we will see CATL, we will see Tencent Holdings. If we scroll a little bit on here, there's hundreds of these companies. Contemporary Amperex Technology Company Limited, CATL, is listed there, and Tencent Holdings Limited is listed there. They also say that entities that are included on this list may request reconsideration. Of course, they don't actually identify what they were basing this decision on in this document, so it's a little bit of an odd process as it stands. You usually see a little bit more due process for American entities in other contexts rather than just being named on a list, a blacklist, as Bloomberg puts it. But they do have some legal recourse, as we will see. But everything related to this list is listed as happening under Section 1260H of the 2021 Authorization Act. But if we go and we look at the Trump articles here, Trump bans investments in companies that White House says aids Chinese military as linked to by The Verge, we'll see reference to a different act. President Donald Trump on Thursday signed an executive order barring Americans from investing in a collection of Chinese companies that the White House believes support Beijing's military. We can link this entire article that The Verge again linked to as part of their reporting to this executive order that was issued on November 12th, 2020, Executive Order 13959, that says that President Trump, by the power vested in him under the International Emergency Economic Powers Act, or IEPA, which you'll see referenced in other places as part of this video, says that Americans can't invest in these various Chinese companies as defined in Section 4A1 of this order. So we're going to follow along in this executive order to 4A1, and we will see that a communist Chinese military company for purposes of this executive order are those companies designated pursuant to Section 1237 of Public Law 105-261. Now, importantly, public laws, the way the acts are actually passed in Congress, they can change their numbering as they go into various statutes in various places in the Federal Register. But here, Section 1237 is actually describing something completely different from Section 1260H. So when we go and we look at the executive order and what the DoD released as part of the designation of companies under Section 1237, we see a completely different list under different defined terms under a different act, the National Defense Authorization Act of fiscal year 1999. So a different year, a different section, a different act, a different list. And yes, if you're sitting there saying, Hoeg, this is crazy. The U.S. government keeps very similar lists of very similar companies with a lot of overlap under different parameters, under different laws, and uses them differently under executive orders and otherwise. I say, yes, that's crazy, but that's what they do. That's what I found in this research. That's what we will see as we look a little bit further on this concept. And in order to understand this a little bit better, I did reference other think tank type content that I found to be very helpful in understanding this. This is from a website called Lawfare, which is done in connection with the Brookings Institution, which we'll take a look at in terms of their bona fides in just a minute. Chinese military civil fusion and Section 1260H. Remember, that's the list we're talking about. Congress incorporates defense contributors, and they go over a lot of what happened here. One provision of the William M. Thornberry National Defense Authorization Act for fiscal year 2021 requires the U.S. Department of Defense to publish an annual list of Chinese military companies, as we saw referenced in that particular designation. Congress passed Section 1237 of the NDAA for fiscal year 1999 to ensure Americans would know whether their tax dollars were funding the People's Liberation Army. And here's where you start to see how Bloomberg, how The Verge, how others on the internet got a little bit confused on this point, because Section 1237 really does point with specificity to the funding of the People's Liberation Army. Congress directed the Defense Department to identify communist Chinese military companies operating in the United States through a publicly published list. Section 1237 was amended twice. Section 1260H seeks to build on the foundation laid by Section 1237 as amended by creating an entirely new reporting framework to pinpoint companies connected to the Chinese military. So it's a different set of definitions. We'll see how they differ in just a minute, but it's important to understand that when Trump issues that executive order, says Americans can't invest in these companies, it's a different list on different parameters than what we're talking about with respect to Tencent and CATL. That's why Tencent, we'll see as part of this video, goes out there trying to explain things a little bit, trying to say this doesn't actually affect our productivity, doesn't actually affect our sales, because it only impacts sales that might be made to the U.S. Department of Defense, and we don't sell stuff to the U.S. Department of Defense. Reporting requirements. According to the official summary of the amendment, Section 1260H, introduced during the House Armed Services Committee markup process by Representative Liz Cheney and included as part of an en bloc amendment to the 2021 NDAA, extends and modernizes the Defense Department's reporting requirements regarding Chinese Communist Party military companies operating in the United States. The provision specifies that the list must be submitted annually to the Congressional Armed Services Committees 45 days after the Secretary is required to deliver the CCMC report under Section 1237. And this article is a few years old, so this is actually at the end of Trump's term before the Biden administration takes over. So we don't actually have how this is used for the past couple of years, but we do have an understanding of how these two statutes interact as part of this article. Section 1268 works in tandem with Section 1237 to create a parallel reporting framework for identifying these Chinese military companies. The definitions are different. After clarifying that CMCs are not natural persons, the provision explains that a CMC includes any company that is, this is 1260H now, directly, indirectly, or beneficially owned, controlled, or acting on behalf of the People's Liberation Army. That's where you might see the Bloomberg reference again. Or any other organization subordinate to the Central Military Commission. Or, and this is the really important part because it seems to be the only place where Tencent might be implicated here, that is identified as a military-civil fusion contributor to Chinese defense industrial base and engaged in providing commercial services, manufacturing, producing, or exporting. In the new law, the language only specifies organizations subordinate to the Central Military Commission and not other ministries for the People's Republic of China, which 1237 does reference. So in this sense, the new definition under 1260H is significantly narrower than the old definition of CCMCs under Section 1237. Even as the provision adopts a more focused definition overall, it adds a new class of companies, which this article says is to tailor it even further. I don't see this as tailoring. Again, this article is from the Lawfare Institute in cooperation with Brookings, and I think it takes a fairly positive tack to what this law is. I'm going to try to not editorialize too much, but this is a political question here. So reasonable minds can differ as to whether this entire process and these definitions are a good thing. But in this article, the author seems to be suggesting that they are. Additionally, it creates this entirely new class of companies, military civil fusion contributors to Chinese defense industrial base, as ones that need to be listed here. And though it isn't separately defined in the statute what a military civil fusion contributor is, it does include a list of what these companies might be. And that list is entities knowingly receiving assistance from the government of China or the Chinese Communist Party through science and technology efforts initiated under the Chinese military industrial planning apparatus, entities affiliated with the Chinese Ministry of Industry and Information Technology, including research partnerships and projects, and affiliated with, also not defined, gives a certain amount of broad authority to the Department of Defense to make these designations. Entities receiving assistance, operational direction, or policy guidance from the State Administration for Science, Technology, and Industry for National Defense. Any entities or subsidiaries defined as a defense enterprise by the State Council of the People's Republic of China. So that's a designation that would happen in China. If it has that designation, if it gives certain control to the Chinese government itself or these various other ministries, then it could be listed as one of these fusion companies. Entities awarded with receipt of military production licenses by the government of China. Entities residing in or affiliated with a military civil fusion enterprise zone. Entities that advertise on national, provincial, and non-governmental military equipment procurement platforms in the People's Republic of China. Or, and here's where the rubber really hits the road to me, any other entities the Secretary determines is appropriate. Now, we've talked about it in Virtual Legality and in other contexts in the past, but Congress likes to write these laws with an umbrella provision at the end. to say we've listed everything we could think of, but we don't know what we don't know, and we don't know what we can't think of right now. So we want to give one of these agencies, in this case, the Department of Defense, some broad authority to say, okay, on this list, maybe you didn't cover this exactly right, but it would be appropriate for this company to be included for reason X. The last category in the class of MCFCs, as described here by Brookings and Lawfare Institute, leaves a great deal of discretion to the Secretary of Defense. However, given that this category comes after a list of more specific categories, the canon of legal interpretation known as usidem generis of the same kind, which provides that when a law lists a class of persons or things, any general language after it is interpreted in line with that list will likely guide its use. And again, this takes a very kind of genteel approach to congressional law drafting, right? This takes a very generous kind of assertion of how courts will interpret these things. We saw during the COVID pandemic and other areas of emergency designations and legal declarations by governors and presidents across our country that perhaps this language here is interpreted a little bit more broadly by the courts than this particular article would suggest. Again, reasonable minds can differ as to whether or not that's a good thing here, whether the Chinese military company issue is important enough that the Secretary of Defense needs to be able to essentially list whoever they want, as long as they determine it's appropriate by whatever means they might think is appropriate in that particular context. But I don't really agree with this paragraph as part of this article that says this is terribly limiting based on everything else that's in this list. Suffice it to say, the notion that the Department of Defense appears to be advancing here is that Tencent, by virtue of its creation of artificial intelligence or other technological infrastructures for video games, media, or otherwise, may well be aiding the Chinese military in ways that are difficult for the United States to see just based on the structure of the company itself. And I have no idea whether that's happening at Tencent. I don't know that the Department of Defense actually has any idea whether that's happening, but it is part of this story. It remains to be seen what executive action the Biden-Harris administration will take. Again, this is years ago that this article was written, but the Trump administration likely wanted to maintain maximum flexibility when it targeted these military companies under 1237, leading it to declare a national emergency and employ the broad authority provided by IEEPA, using its authority under 1237, rather than simply using its authority under 1237A1. That decision means that the Biden-Harris administration could amend the Trump-era executive orders. There's no indication in my research that happened. But absent further executive action, Section 1260H is still likely to have a large impact simply by naming and shaming CMCs. Section 1260H appears to be one piece of an ever-increasing mosaic of naming and shaming efforts by the United States vis-a-vis China. In the context of Chinese military companies, Congress began assembling this mosaic more than 20 years ago with Section 1237. Now that sanctions have been levied, Congress may not have included a sanctions regime with Section 1260H because the president could simply amend the existing CCMC executive orders to cover CMCs under his IEEPA authority. Said another way, Trump decided to use 1237 for this purpose based on those definitions. 1260H was not used, but the Biden administration could amend those executive orders or issue a new executive order, including 1260H, or the next Trump administration could do the same and have those same prohibitions applied to a list like this using that very, very broad IEEPA authority, basically that there's an economic emergency that can be handled through his presidential authority. And again, I've had issues in Virtual Legality and other locations about the broad discretion given to things like executive orders at both the governors and presidential levels, but reasonable minds can differ on that as well. More importantly, says this article, Section 1260H's narrow and tailored language, and I again object to that description of what we've seen here in the definitions, likely demonstrates the U.S. government's desire to call out the specific issue of Chinese military companies and the MCF, that's the Fusion Development Strategy, from a more precise and up-to-date angle. Moreover, the inclusion of the military-civil fusion contributors subcategory gives the Department of Defense another avenue to define Chinese entities that are connected to Chinese military and defense apparatus, but not be bound by some of the definitions in the earlier designation. Even so, this article admits, some aspects of Section 1260H's designation remain intentionally or unintentionally ambiguous due to broad drafting. More precise terms or the adoption of a specific definition for these various terms might help clear this up. But as we will see, the Department of Defense has done this list now for a few years and has resulted in legal action in a couple of instances. But the most important thing to take away from this is understanding that there are two sets of designations, two sets of statutes, and that what is implicated by Tencent's inclusion on 1260H's list is not the same as being included on Section 1237's list, and that the Trump executive order doesn't discuss 1260H at all. Now, I also want to mention here, as I said, the Brookings Institute is listed by many as centrist, conservative, liberal, center-right, and center-left, as Wikipedia reports here. So it's not really very useful analysis for understanding where they're coming from politically. An academic analysis of congressional records found that Brookings was cited by conservative politicians almost as often as liberal politicians, earning a score of 53 on a 1 to 100 scale, with 100 representing the most liberal score. So it's hard to place them in any specific bucket, although reading that article, as I will link in the description in the podcast version of this video, you do get the at least indication that they are definitely okay with more aggressive listing, naming, shaming, whatever else you want to call it with respect to Chinese interactions in the United States economy. That all said, if we look a little bit further, we can understand that what 1260H does is it prohibits the Department of Defense from entering into a contract with an entity on that list starting on June 30th, 2026, or purchasing directly or indirectly goods and services that include goods or services sourced from an entity on that 1260H list starting in June 2027. So the Department of Defense will be bound. They will be prevented from buying League of Legends, currencies, various other things, to the extent Tencent Holdings stays on that list for purposes of 1260H. That doesn't really make much of a difference to Tencent's bottom line on the whole, but the fact that they're included on this list and the fact that an executive order might be amended or issued by the Trump administration at really any time to include the companies listed on that list in the prohibition of American investment concept does lead to a reduction in their stock price, probably leads to a reduction in their business opportunities, partnerships, potential licenses that they could enter into with folks operating in the United States. And that they might think is a problem because Tencent, if you don't know, and I suspect that you do, is a real big company. As Wikipedia says, founded in 1998, its subsidiaries globally market various internet-related services and products, including in entertainment, artificial intelligence, and other technology. Tencent is the world's largest video game vendor, as well as one of the largest companies in the world by market capitalization. Its services include social networks, music, web portals, e-commerce, mobile games, internet services, payment systems, smartphones, and multiplayer online games. They're a conglomerate, but they're a conglomerate focused on what we might consider entertainment. And in the video game landscape, they own parts of practically everything that you can think of. They wholly own Funcom, Riot Games, Sumo Games, Grinding Gear Games, if you're enjoying Path of Exile 2 right now. They own controlling interests in Visual Arts, Turtle Rock Studios, Tequila Works, Clay, others. They own majority shares and also controlling interests in Supercell. They own plurality of shares in places like Don't Nod, Pocket Gems, Shift Up, Epic, Bloober, Marvelous, and more. They have important interests in Remedy from Software, Katakawa, you saw us reference in Virtual Legality earlier this year. And so basically, they're a major player with their fingers in all sorts of different video game pies. And that rubs a lot of people the wrong way. And I'm not going to tell them they're wrong, but it does mean that inclusion on this list could have a deleterious effect on a whole host of aspects of the video game industry. Which leads us to the last point that I wanted to talk about as part of this particular issue, legal action. So a number of places reported after that the U.S. designated Tencent a Chinese military company, with the list serving as a warning to American companies and organizations about the risks of doing business with Chinese entities, that Tencent threatens legal proceedings if the U.S. doesn't overturn decision to label it as a Chinese military company. Now, I was interested in what it meant to threaten a legal proceeding of this type. I suspected it was just the standard end of a statement, and I was proved right when we look at the statement here. Tencent responded to this by saying, hey, the company noted that the U.S. Department of Defense has scheduled to publish the Notice of Availability of Designation of Chinese Military Companies on 7 January 2025. Pursuant to the notice, the Deputy Secretary of Defense has included the company in this list, as the company is neither a Chinese military company nor a military-civil fusion contributor to the Chinese defense industrial base. It believes that its inclusion in the CMC list is a mistake. Unlike other lists maintained by the U.S. government for sanctions or export control measures, inclusion in this list relates only to U.S. defense procurement, which does not affect the business or the group. So this is essentially a statement to investors, right? Our share price is going down. This is a bad thing that we're included on this list, but you should know This is not what Bloomberg reported. This is not the Trump prohibition list. This is only about Defense Department procurement. The CMC list is distinct from non-SDN Chinese military industrial complex list maintained by the U.S. Office of Foreign Assets Control, a different list that the U.S. government uses. And inclusion in the CMC list will not prohibit any persons other than the Department of Defense from business dealings with the company, including transacting in the securities of the company. So don't feel like you are going to lose whatever value your equity position in Tencent might have due to our inclusion on this list. Obviously, there is some confusion. There was confusion in the reporting. There's probably confusion at the shareholder level. And so we feel the need to make this statement. The company intends to initiate a reconsideration process to correct this mistake. But from a legal perspective, the same entity that made the initial designation is in charge of the reconsideration process. So probably we're not holding out a lot of hope for that process to bear fruit. During the process, Tencent, will engage in discussions with the U.S. Department of Defense to resolve any misunderstanding, and if necessary, will undertake legal proceedings to remove the company from the CMC list. The company will make further announcements as and when appropriate. So this, if necessary, will undertake legal proceedings to remove the company from the CMC list, is shown by these journalists as threatening legal proceedings if the U.S. doesn't overturn decision. But from a legal perspective, from a lawyer's perspective, this is what you put at the end of a demand document or a letter to the opposing counsel that says, look, we're going to ask you to do this the right way. We're going to use your process if necessary. But just because we're using your process, just because we are acceding to this particular set of demands, it doesn't mean that we're giving up our legal rights in the future. So Tencent here, to my ear, is effectively saying, hey, we'll go through your reconsideration process. But if that doesn't work, we will undertake legal proceedings to remove the company from the list if necessary. So this isn't really threatening legal proceedings if they don't remove them as much as it's saying, we'll use your process, and that doesn't mean that we're giving up the right to sue you in the future. And also, hey, some folks have had some success suing you. Now, this is the DJI drone company complaint that The Verge published and linked to in that initial article that we looked at the top of this video. But I wanted to highlight for you what a lawsuit, what legal proceedings might look like on this particular count. And the basic nature of this is, in the context of this particular instance, DJI says the Department of Defense didn't talk to us about including us on the list, didn't respond to our answers or the reconsideration process that says why we shouldn't be on this list, and is acting arbitrarily and capriciously under their authority given to them by Congress. And that's important for U.S. law. Under administrative law, these agencies, these executive branch parties, the Department of Defense in this case, are not allowed to just take their authority that Congress gives them and use it willy-nilly. They're not allowed to act arbitrarily or capriciously in legal parlance. And so this lawsuit alleges that that's what's happening here. The statute invoked by defendants does not authorize their action because we don't fall under any of the definitions provided. Defendants have authority under Section 1260H to identify each entity the Secretary determines based on the most recent information available is operating directly or indirectly in the United States or any of its territories and positions that is a Chinese military company, but that they shall make additions or deletions to that list on an ongoing basis based on the latest information available. Section 1260H permits the Secretary of Defense to designate the companies if one of either two conditions is met. First, the Secretary may designate a company if it is directly, indirectly, or beneficially owned, controlled, or acting on behalf of the People's Liberation Army or any other organization subordinate to the Central Military Commission, but we are not owned, controlled, or acting on behalf of the People's Liberation Army. Second, the Secretary may designate a company as a CMC if it is a military-civil fusion contributor. We saw that description in the Lawfare article we read earlier, but we do not fit in any categories listed by the statute. Therefore, we do not qualify as a CMC, and in failing to remove us from the list, defendants failed to abide Congress's mandatory command that they shall make deletions on an ongoing basis based on the latest information available. Defendant's designation is therefore arbitrary, capricious, and abuse of discretion or otherwise not in accordance with law, and is in excess of statutory jurisdiction, authority, or limitations under the Administrative Procedures Act. And they say there's other violations here. They failed to articulate a satisfactory explanation for designating us as a CMC, which this list process itself doesn't really give these companies enough information, in my view, to feel like they're getting due process under United States law. And you can feel one way or the other about that to the extent that these companies are interacting with or helping the Chinese military. But we do have rules in the United States about these agencies acting arbitrarily and capriciously. And I think that's part of this story. Or as DJI says in their lawsuit, reasoned decision-making requires that an agency articulate a satisfactory explanation for its action with a rational connection between the facts found and the choice made. Defendant's conclusory analysis does not provide a rational connection between the facts found and decision to designate us as a CMC. This includes, but is not limited to, defendant's failure to make the legal conclusion necessary under 1260H, under those two categories that we just talked about. An agency's factual findings must be supported by substantial evidence. Here, the evidence that defendants purport to rely upon is either false, contravened by the public record or DJI's delisting petition, or insufficient to support defendant's factual finding that we are a CMC. So this is what Tencent might look like fighting this particular designation. Again, from my perspective, editorializing a little bit here, this is the kind of thing that the US government is doing realistically on an arbitrary basis on its own, to the extent that the Department of Defense is just providing that list and not otherwise providing any information about any of the entries on that list, that they're immediately blacklisted, described as such by Bloomberg, that their share price immediately goes down based on this sole authority to designate by the Secretary of Defense. But a reasonable mind can look at this and say that's necessary for the national security. And I think that you can have a good reasoned debate on that topic. Please do in the comments or otherwise, should you see fit. But this is what that lawsuit would look like. And I am trying to make these videos 30 minutes or less. I don't know that I'm going to make it this time, but I do want to leave you with that information and let you know that if you enjoy and find these conversations informational, educational, and helpful, please do consider supporting the channel at Playor or Patreon. I'll have links in the description, or through memberships to the channel, super chats, and the like on live streams. Otherwise, you can find me on Playor, formerly Utreon, at a website like this one to watch your videos there or otherwise support the channel. And questions or comments are welcomed to the comments to this video. I do try to respond to as many as I can substantively when I get the chance to after these videos. Otherwise, just telling folks about this channel, telling your friends, every little bit helps. So thank you so much. I hope this was informative to you, and I will catch you on the next episode of Virtual Legality.
Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.